Good morning. Welcome to 2026. Yes, we're here somehow. So today is our first day for a panel for the year, January 12, 2026. We have 5 cases that are on the docket. 4 are going to be arguing today. Just so that council knows, at this juncture, our plan is to go ahead and argue these straight through. So we're not going to take a pause. If anything changes, we'll let you know, okay? So the cases that we have, the first case that we have is C240714, 250239, Marie Onstead versus Susan Erickson. If council can identify themselves and their readiness to proceed.
Louis Schneider, counsel for the appellant.
Your Honor, Paul Shore for FLE.
All right, thank you. The next case we have is C250205, Carolyn Dotson versus Durrani et al.
Bill Robson on behalf of Alan Schneider.
Good morning.
Ready to proceed.
Good morning.
Alan Stavin,
Good morning. The next case we have is C250278, Geico Insurance versus Glendale Body Shop.
Justin Becker for Glendale Body
Good morning.
Shop. Bill Moran on behalf of Ali Geico.
Good morning. The next case we have has submitted on its briefs. It's case number 250221, State of Ohio versus Avena Star. And then the last case on the docket is C250172, State of Ohio versus Devon Courtney. Good morning.
Phil Cummings from State of Honor.
Good morning. Okay. All right, counsel, good morning again. Would you like to reserve time?
5 minutes, Your Honor.
All righty. You can start whenever you're ready.
Thank you, Your Honor. Good morning, Your Honors, and may it please the Court. Louis Schneider, I'm here on behalf of appellant Marie Onstead. This is an appeal of 2 issues. The trial court granted summary judgment in favor of the defendants in this case. It's appellant's position that was improper. And then when we sought relief under Rule 60B, trial court failed to consider it and take into consideration the evidence that they wouldn't consider when deciding the Rule 56 motion. The background of this case actually goes back to Wisconsin. Marie Onstead is the widow of a man named Daniel Onstead. He was a basketball coach of basketball, coming home from coaching basketball. He owned a physical therapy business with his wife. While he's driving home, Mr. Erickson was intoxicated, drove left of center, and hit Mr. Onstead head on and killed him. This case involves service of a family foundation, like a family trust, that it's the appellant's position that Mr. Erickson was essentially up there on the business of at the time that this accident occurred. So we filed a suit here in Ohio against Mr. Erickson's estate and also named the family trust as a defendant in that case. We sought certified mail service based on the limited information that we had about the family trust at that time. And we also had the understanding that since Mr. Erickson was up there on behalf of the family trust, serve as estate, serve as widow, that would effectuate service. Nonetheless, the defense in this case, or the appellee in this case, that can't serve the widow, they're not the appropriate trustee. But the appellee and also the trial court refused to recognize that we actually did obtain appropriate certified mail service through the United States Postal Service with certified mail, return receipt, signed on the green card by a person named Scott Erickson. And Scott Erickson had actually become the successor trustee of this trust.
He was a co-trustee, was he not?
He was, and he was also a successor trustee at the time because I think it was 3, and then it became 2.
So this information is all on the docket.
Absolutely in the docket. It's in the docket beginning in March of 2024.
And that's when he was served.
Yeah, he was served, I believe, on March 14th of 2024, and it made its way to the docket on, I believe, March 18th of 2024. As this court may be aware, certified mail moves very slowly, and it is it's a difficult method to obtain service sometimes. But when you get it, you get it. It's right there.
So that's how you serve a trust. You serve one of the trustees
Mm-hmm.
under the rules. Did the judge just overlook this fact that this was on the docket sheet, or?
He overlooked it in 3 ways.
Okay.
He overlooked it, that fact on the docket sheet. He overlooked it actually in an affidavit that was filed by the appellee that was signed off on by Scott Erickson saying, yeah, I got the green card down in Florida. I signed for it, but I didn't sign for it as the successor trustee. I just signed for it because it said Scott Erickson on it, even though it was directed to the family
So he ignored
foundation.
the affidavit, or he treated the contents of the affidavit in a different way than you believe it should have been treated?
He ignored the affidavit.
Okay.
There was no mention of that, even though we had addressed that specific content of that affidavit with the trial court when we filed our response to the motion.
Did he say that Mr. Erickson wasn't served at all, or I'm just confused?
Which Mr. Erickson? Scott Erickson?
Scott, 'cause
Oh,
that's,
Scott.
that's the trustee that was served.
Yeah, he was served.
I know, but what did the judge say as far as that service?
The judge didn't address it and ignored that service. He just
So-
didn't address it at all. He said that the service of the widow was not effective.
Right, and you agree with that?
I don't agree with that.
Okay.
But for purposes of this appeal, it's not important because we did serve Scott Erickson as the successor
And so he just
trustee.
overlooked that fact?
Yeah,
Okay.
he did. He only overlooked it in the affidavit. He overlooked it on the docket. And he also overlooked it when we took the deposition of Scott Erickson. And I confirmed in my 2 pages of deposition testimony that's cited in my brief, hey, Scott, did you sign for this? Yes. This is your signature? Yes.
When you're saying he overlooked it, you're also saying that the trial bench, was the trial bench silent
Yeah.
as to? Okay.
Yes.
Yeah, because
Yeah.
this got converted to a summary judgment.
Yes.
Right?
Yeah.
And the bench was silent. So it could be that he overlooked it, but it also could be that he applied the wrong law.
Either way, the trial court.
We don't
erred.
know.
Either way, the trial court, and Your Honor, we even addressed this in our Rule 60 motion and said, hey, you overlooked this. You overlooked it on the docket, you overlooked it on the affidavit that was filed, and you refused to consider the contents of this deposition, which clearly shows that Scott Erickson got this green card down in
Did
Florida.
he even need to look at the deposition in order to decide? I mean, all he needed to do was look at the docket, right?
Right.
Yeah.
And it's clear on the docket. I mean, you
Yeah.
know, the Hamilton County court system is great in their electronic document. They keep the green card, they scan it in, you've got all the tracking information, and you've got the actual ink signature. And unless somebody comes in and says, that's not my signature, that's, you know, Rick's, and he doesn't even work here or anything else like that, we don't have that here.
Right.
We have Scott Erickson admitting in his affidavit that he signed for it, and confirming in his deposition that signed for it. And we've got the trial court just ignoring it, not applying the appropriate law, not recognizing it.
So
Just to be
Scott-
clear, I'm sorry.
I was going to say, so Scott acknowledges that he signed for it, but he is basically addressing in what capacity, the capacity in which he signed for it.
I think that's fair. However, it's clearly.
I'm not saying he's right, I'm just saying this is, so.
The
how
envelope
would you
and the
address?
green-
How would you address that portion of it, of like, I signed for it, but it wasn't in the capacity of a trustee?
Right. I'd specifically address not just to Scott Erickson, but to the Bruce and Mary Ann Foundation. The envelope, when it comes in, the address has that from the Hamilton County Clerk of Courts. Attention, Scott Erickson. So if Scott Erickson says, oh, you know, I've got nothing to do with that, or that doesn't have anything to do with me, he can refuse to sign, he can do anything else. He signed for it. He admitted in his deposition that it was addressed to the foundation. He admitted that he was the successor trustee. He stated in his affidavit, well, I didn't sign for it as the successor trustee because I didn't write successor trustee when I signed for it. There's no case in Ohio, it makes no sense. That argument is nonsensical. When you address something to a foundation or a trust, and you address it to the person that's associated with that, and they signed for it.
Ultimately, does that matter? I mean, I'm looking at what the rule says, and it says signed by any person accepting delivery. So does it matter that whether he signed it in his capacity as an individual or as a trustee?
It doesn't, and Your Honor is correct. However, that argument is the argument that the appellee put up in front of the trial court and is put up in the briefing in front of this court. Now, the trial court, like I said, didn't even consider that certified mail that was on the docket, didn't consider the information that was in the affidavit, didn't consider the deposition transcript. But service was appropriately obtained on the Family Foundation by when Scott Erickson signed off on that green card. If they're saying that the widow can't sign for it because she doesn't have capacity under the terms of the trust, but Scott Erickson does, well, we clearly showed to the trial court, yes, he signed for it, we got him, and we got him within a 1-year time period of when the First Amendment complaint was filed. So we've met the Ohio Civil Rules requirements for service in terms of time. We've met the Ohio Civil Rules requirements of service in terms of signature and who received it. At that point, the defendant, the foundation, had even filed an answer. They had already been notified of the case when Mrs. Erickson, the widow, got it. They put an answer on, so they were already in front of the trial court on it. So there's no prejudice to them, you know, hey, somebody signed for this and we don't know what's going on. They just sat back and said, we didn't service within that 1-year period. Well, too bad for them, we actually did. And so it was very surprising that the trial court made this decision wherein it completely ignored kind of these foundational requirements that I use as a plaintiff's attorney constantly all the time. Is green card service okay? Yes. Did somebody file an answer? Confirm with the person whether or not they've got service, whether or not, you know, they're appearing, how they're appearing, all that stuff. The appellee in this case wouldn't do that. They
It
wouldn't
seems
waive
like the
service.
judge was faulting you for not submitting contra affidavits.
Yep, that's true.
Okay.
There was an extensive discussion about we did not submit contra affidavits. However, when the affidavit in place, as well as the documents that are contained on the docket, the certified mail, say, you know, hey, this person was appropriately served, we're more than appropriate. We can rely on that.
Did
as-
the burden even shift over back to you?
It didn't.
Right.
Not on that issue. No,
Right.
not on that issue. And that's the issue that the trial court hung its hat on, which was you failed to appropriately obtain service. And we didn't just not.
If you want to wrap up.
Okay. Your Honors, I'll address this further on rebuttal. Thank you, Your Honors.
All right, thank you.
Good morning, Your Honor.
Good morning.
May it please the court, my name is Paul Krauscher. I'm representing the Bruce and Mary Ann Erickson Family Foundation Trust. 4 points I think are relevant for this, what just happened. Most importantly, the family trust, EFF, as it's been referred to throughout the litigation, was never named in the lawsuit. Therefore, service on this entity that doesn't exist was not effective regardless of who received the green card.
Well, let me push back on you a little bit on that. Civil Rule 3A, I believe, it specifically states a remedy for if a defendant is incorrectly named.
Yes, ma'am.
Why, and also, I believe that your client actually said that the trust is known either as the Erickson Family Trust or the Erickson Trust equally. So what's the problem exactly here?
Well, the problem is that the entity is a trust is not sui juris. You can't sue a trust.
Did you put that in the answer?
Yes, ma'am. In fact,
Was that a defense in the answer?
It was raised as the third defense and the fourth defense process. It was insufficient as to this defendant. The answer was in the name of the trust. So the trust appeared and said, you don't have service on us. We're not a proper party. The third defense and the fourth defense was insufficiency of the service of process.
But insufficiency isn't the same as capacity.
Well, yes, ma'am, but this is an answer to the allegations in the complaint. They allege throughout the answer that they are not the entity that was named. Then that they had a year passed between when the thing was filed, actually quite a bit more than a year, and when any attempt was made to do discovery, to do depositions, to do anything to ask these questions about who this is. There's no Rule 15 John Doe's. There was no allegation that, by the plaintiff, that there was anything, that it was suing the trust that eventually answered. There is no capacity. The issue was that because it never was a party, first, it never should have been a party because Mark Bruce Erickson was in Wisconsin on personal business, not on the trust business. The only evidence adduced by the plaintiff as to anything was a tax return which was incompetent. So there's no evidence as to this entity ever being formally notified that it is being sued. They appeared because it's wiser to appear and raise the issues, but that doesn't make it a party. That doesn't make it properly served. The trustees have to be named, and they never were named. In both Wisconsin and Ohio, the trust being non sui juris is not a proper party ever, anyway.
So you say this was raised in the answer?
Yes, ma'am, the third defense and the fourth defense.
Okay.
Sufficiency of process and sufficiency. Third is process by which the plaintiffs requested an issue to the Bruce and Mary Ann Erickson Foundation at the address in Cincinnati was insufficient as to this defendant, and that the service of process on Bruce and Mary Ann Erickson Foundation was insufficient as to this
So
defendant.
that's about service. Again, to
Yes.
Judge Brock's question,
Right.
there was no issue of capacity specifically raised, or you're saying that's interchangeable?
Well, that was raised in the motion for summary judgment, Your Honor.
Okay, but doesn't it have to be raised in the answer?
I don't think so, Your Honor, because the answer is just the formal appearance
Okay.
and the raising of issues. It raised the issue as to whether it was a proper party in that answer. So in a way, it wasn't listed as a specific defense, I don't believe.
But the judge didn't dismiss this case based on capacity.
Well, Your Honor, he said the Bruce and Mary Ann Erickson Foundation is not a proper party. Because it's not a proper party, because it's not a legal entity. That's the page 3 or 4. He didn't number his pages, so it's under the service of process heading.
Okay.
And it's not a proper party. And it couldn't be a proper party because it's a trust. And it wasn't named in the complaint.
So your argument is not that there's a word missing out of it. Your argument is that it can't be sued at all.
Correct. You have to sue the trustees. They weren't the trustees. Further on, the judge says, EFF further argues that to obtain service on EFF, plaintiff must serve a trustee, which was not done in this matter. It did cause him to receive a paper, but it didn't name him. So if it's not named, then he hasn't been served. So the other issue here is the timeliness and the tardiness. The standard of review is de novo, is abuse of discretion, and I filed that supplemental case from this court. Basically, they're saying we're excused from the rules. We don't have to adduce evidence because we're right, and it's just made a bunch of unsupported allegations.
Are you talking about the affidavits that didn't make its way in front of the court? I'm not sure what you're addressing right now.
Your Honor, basically, the argument that they made to the trial court, the only thing they gave to the trial court was an unsworn, uncertified, unauthenticated printout of a tax return, which, with no explanation of what that means, no expertise on what it is. You know, I have an advanced degree in business and tax, and I don't know what that thing means. There was no explanation to the judge as to how this supposed document means anything, and they didn't provide anything else. The only thing they have was the depositions, which were not limited, but they were full depositions. They weren't timely filed. They took them, but then there was no request to the judge for time. Instead, they waited until what he says was, what appellant says was a notation on the docket that it was deemed submitted, but the judge had put on order. They'd asked for time to respond to the motion for summary judgment. They got that time. They got far more time than they were entitled to, and they still didn't come up with any evidence that the decedent was in Wisconsin doing trust business, that the trust was in fact susceptible of being served as a trust. And of course, if it's a corporation, that Berhane case says, obviously, it's easy to get service. But you can't get service on something that you never named, and there was no attempt to change the name, to list the trust as a defendant. So basically, we had the filing of the lawsuit February 2023, nothing until January 2024. And without some progression of the litigation, there has to be a cutoff. And in fact, they had exceeded the cutoff when it was brought to the judge's attention that the superintendent's rule requires ruling on motions timely. He did rule. He did rule after the depositions were filed. So this claim that he didn't think about things or he didn't consider evidence, we can presume that he considered the evidence that was before him when he entered this order, because he ruled after the evidence was submitted. There's no indication that he didn't consider it. He didn't say in this order, I'm going to not consider those.
So the evidence came in after the time allotted for it to come in, but before the determination on the summary judgment?
Yes, ma'am.
Is that correct?
I think
Okay.
by about 11 weeks.
All right.
So they had ample time to do something. They just didn't do it.
Was evidence, I mean, because the signature of your client was actually on the docket, I mean, the green card was on the docket,
Yes, ma'am.
why would they need to submit evidence or an affidavit to authenticate it? It's already on the record.
Well, because first, they did make the argument, it's true, but I don't think that argument is controlling here.
Why?
Because you can serve somebody without notifying them what you're serving them with. I would agree with that. But you can't serve someone who's not a party as an officer of an entity that doesn't exist.
You seem to be conflating two different issues. One is service, and the other is capacity to be sued.
Yes, ma'am.
They're separate, but you
Yes.
seem to be conflating the two.
No, I'm actually making the point that serving a trustee of a paper that says Onstad versus an entity that doesn't exist is not effective. It doesn't achieve anything. It's like, I can hand you anything, but that doesn't make it a valid service.
Let me make sure I understand what you're saying. When you're saying an entity that doesn't exist, are you talking about how the trust was listed? And as I understand, there was a piece missing, but there was also evidence that it was understood, even with that piece missing, to be the trust. So are we talking about that? Or are we talking about capacity?
Your Honor, we're talking about both. First,
Okay.
it wasn't understood to be the same because the trust is not a legal entity and cannot be sued. So it can't be the same. You have to sue the trust through its trustees. Both Ohio and Wisconsin laws are clear on that. And trial counsel for the appellee made that point to the judge.
So basically what you're saying is there was a suit filed, but it was to the improper party.
Yes, Your Honor.
Because that party does not exist. Regardless of how that party is listed, it simply does not exist as an entity that is suable.
Correct. And so it's sort of the appellant threw off a couple points
Okay.
in the 60B motion and in the brief.
Let me get back to this, if you don't mind, into the pleadings and the summary judgment. So I know that you've referred to defenses number 3 and 4 on the answer,
Yes, ma'am.
okay? But then you also mentioned that you did raise specifically capacity in your motion for summary judgment.
Yes, ma'am.
Was there any opposition of like, hey, that was not raised at the pleading stage, and you can't raise it now in summary judgment?
I don't believe there was, Your Honor. There was no motion to strike. There was no, the only response was factual in both the response to the motion for summary judgment was just the statements of counsel with one attachment, and then the 60B was the statements of counsel with an affidavit with that same piece of evidence.
Okay. And do you know, can you cite anything that as a matter of law, that, that the trial court can consider it regardless of the fact, if in fact it wasn't pled, and I know you believe it was, that the trial court can still consider it when there's lacking any opposition?
I do not have such authority. If you'd like, I can be happy to submit a supplemental.
Okay. We'll let you know.
Okay.
Right.
Thank you, Your Honor. The main thing here is this deadlines issue, other than what we've already discussed. You know, the plaintiff asked for a deadline to file evidence, didn't file anything except this tax return that doesn't actually mean anything. We got, at that point where they filed the motion to dismiss, the case was 14 months old, and so the deadline had long passed by then. He asked for time to respond. The judge gave him, I think, about 11 weeks to do that total from the time that the motion to dismiss that was converted into a summary judgment motion, and by the time the answer, they just never got around to responding. They didn't do anything until October 2024 was filed. The depositions were taken in June. No motion for an extension. No motion. No explanation even to the trial
But
judge.
it seems to me the argument you're making is a legal argument of capacity. It's an issue of law, not an issue of fact. So either you're right as an issue of,
Yes,
as a
ma'am.
matter of law, or you're not right as a matter of law. So failure to respond, I don't know how that would go into that, other than bringing authority otherwise.
Well, capacity, you know, issues are raised to the trial judge, Your Honor, and then somebody has to say to the judge why it's wrong. They've got depositions, they've got discovery, presumably. They've got any piece of evidence. What piece of evidence did they not have that the court decided the case wrong as to who the entity was? There's just nothing provided. So they're leaving the trial judge in the lurch with it by not giving him anything and not even telling him, you know, what we're doing, why we're doing it.
So you have a half a minute left if you.
Thank you, Your Honor.
If you want to wrap up.
I think I've covered it.
Okay, very good.
Thank you, Your Honor.
Can I ask you real quick, what was the second amended complaint that you asked to file? What was that going to correct?
The name of the.
Just adding a word?
Yeah, I mean, if they were going to make the argument that the
Okay.
Bruce and Marianne Erickson Foundation should have been identified, as the trial court stated, as the Bruce and Marianne Erickson Family Foundation.
Okay, so
That
that
would-
didn't have anything to do with capacity and suing the actual trustees, as he was just arguing?
The issue, no, Your Honor. And that issue was not actually even addressed by the trial court.
Well, that was my question earlier, because I'm looking at his order and I'm trying to figure out, was capacity raised, is this what? Because it seems like everything rises and falls with capacity here unless it was waived, right? If you can't sue a trust, that's the only defendant here.
You can sue a trust through, by identifying
Through the
the
trustees.
trust, naming the trustees as the people to accept.
they're not
ser-
named in the
ser-
complaint.
Service from it. No, they aren't
Okay.
named in the complaint. The capacity wasn't addressed in the answer. And he cited to the affirmative defenses that were raised.
Was it addressed in the summary judgment? Was it argued in summary judgment?
There was briefing on summary judgment. However, the appellee's position that you've got to sue the trustees, and I know he's addressed that position here, that's not what Ohio law says. Ohio law says if you sue the trust and you name the trust and you name the trustees in there, you can file suit against.
Right, but here only the trust is named as a party,
Yes.
right?
Yeah.
So
Yeah.
what he's arguing is that you can't solely name the trust, that you also have to name the trustees, because the trustees are really the parties, the proper parties that'll stand for the trust.
I understand the argument that was being made by the appellee. The trial court actually didn't even address that in the trial court's order. If that's an issue that needs to be fleshed back if this case is remanded back down to the trial court, obviously the trust has notice of this. They've put an answer on. The people in charge of this trust have had notice under Rule 15, under Rule 3A. If the trust needs to be identified as a defendant in the case, that can happen back at the trial court level. But what this trial court order does not do is say, you did not sue Scott Erickson or these other people as the successor trustees you didn't even know about, because we didn't have access to the trust document at the time. And talking about discovery in this case, there was very limited discovery that was done. And the trial court never put any type of scheduling order on for us to conduct discovery. Instead, there was the issue of service that was raised. We took the depositions of the trustees to figure out, who got served, what service there was. Eventually, the trust document was produced, and it shows that the Bruce and Marianne Erickson Family Foundation is the proper defendant, and that Scott Erickson had capacity to accept service on behalf of that. At that point, if they want to say, hey, well, you should sue us through the trustee or anything else like that, that issue can be addressed at the trial court level. It's not even something that was raised in their answer. Your Honors, if the main focus of the trial court's order was two things. Number one, you left out the word family and foundation, and number two, you didn't actually get service, and they completely ignored the issue of service. The issue of capacity wasn't raised or wasn't addressed in the trial court's order, and it wasn't properly raised by the appellee in its answer. That potentially is an appeal for a different day. But this issue, the issue that's in front of this court now, is whether or not service was proper when Scott Erickson signed off on that green card saying, yes, I'm the person to accept things on behalf of the Bruce and Marianne Erickson Foundation.
So you have about 30 seconds left if you want.
The trial court said, well, there was no evidence of service here. There was clear evidence of service here. We respectfully request this court to reverse the trial court's decision on the issue of service. Send this back down to the trial court with specific instructions to allow this case to proceed. The proper parties, if they have issues with who the proper parties are, those people have been notified of a lawsuit against this foundation, against this trust. That can all be hashed out with the trial court. Thank you, Your Honor.
I just have one question, because some ways to bifurcate it, to address service and to leave capacity and remand it on that. I'm trying to understand whether capacity, it seems to me that capacity is an issue of law. So why wouldn't we be able to address it? What would potentially be gained by a remand on that?
What would be gained on remand is the procedural aspects of capacity, Your Honor, which is if they're claiming that you've got to, sue the trustee versus the actual trust, that can be easily corrected by a Rule 15 motion. That can easily be corrected under Rule 3A, which is these people have known about this lawsuit. They've had this, but default the plaintiff and the appellant in this case for not having the trust documents, for believing that they were actually, filing claims against, the trust and get everything lined up. It's not as if these defendants or these appellees came into court and said, whoa, and
It sounds like what you're
clarity.
saying, and I haven't done the research, but it sounds like what you're saying is that because they availed themselves to the court, and they now have notice of the suit, it's sort of like the ship has sailed with regard to capacity. That's what it sounds like, what you're in essence saying.
It's fair, Your Honor.
Yeah. All right. All right, thank you so much. Thank you both for your arguments this morning. We'll take the matter into submission, issue a timely decision. We have a wonderful 2026.
Thank you, Your Honor. Happy New Year.
So now we have Dotson v. Durrani. Good morning.
Morning, Your Honor.
Would you like to reserve time?
10 minutes, if you don't mind, Your Honor.
Okay, so you're going to argue 5 minutes.
That's correct.
Okay.
And I will, in my argument, explain the reason for that
Okay.
choice.
You can start whenever you're ready.
May it please the Court, Philip Williamson on behalf of appellants. The reason for reserving most of my time for rebuttal is that the only response in Appley's brief is a single sentence saying, we rely on the trial court's order for our position on the issues in this case. So if there's going to be further argument from
So really,
Appley-
you could have reserved to 12 minutes.
That was my original plan. I do have a few things to say about the order itself,
Okay.
but if there's going to be further argument, I'm going to hear it for the first time today and would like to sort of reserve the bulk of my time for addressing that.
Which creates its own appellate issues, doesn't it?
It does, Your Honor.
It kind of makes your rebuttal pretty easy, doesn't it?
I would like to think so. I certainly hope the court agrees that,
No, I mean, if they're going to raise arguments that they didn't raise in their brief, then your rebuttal's really quite simple.
Your Honor, if I have the
But you
opportunity
go-
to
but go ahead.
give you 8 minutes of your day back, I will gladly do it and put myself in the court's good graces. But there are a couple of things about the order that I think it's important for the court to consider. And the first is that the order is wrong about most of the particulars that the court used to justify granting Ms. Dotson's post-dismissal, post-judgment on the pleadings motion to amend. The first is that the court declares that there's precedent for allowing a medical malpractice plaintiff to attach an affidavit of merit in a motion to amend a complaint. That's true. The court's only authority for that, though, is the federal decision in Burgess. The court quotes about half of the relevant analysis in Burgess, and if you read the rest of that paragraph, it demonstrates why Burgess doesn't do anything to help Appley here. So in Burgess, you had a Section 1983 lawsuit against a sheriff, sort of prison system alleging use of excessive force, and there is, in a 10-count complaint, one claim for medical negligence. That complaint is not accompanied by an affidavit of merit. So you get a motion to dismiss in part, and it's a motion to dismiss the negligence claim for lack of the affidavit. What you will find if you actually read Burgess is that the reason the trial court grants a motion to amend the complaint is that you get a motion in response to the motion to dismiss, you get a motion to amend and a motion for leave to file an untimely affidavit of merit. That is in response to the motion to dismiss. Unlike the case here, where the motion to amend is filed 5 months after the case has been dismissed.
Now, let me just clarify. I think I know the answer, but I'd like to hear your position.
Absolutely.
When the trial court dismissed, back in, was that July 2022? I don't remember the date. But when the trial court entered its dismissal entry, that was for all remaining defendants and all claims.
Correct, Your Honor.
There's nothing left.
There was nothing left.
Okay, thank you.
Which is one of the important distinctions from Burgess. So one of the justifications for granting the motion to amend in Burgess is, look, dismissing the medical negligence claim here would not dispose of the entire case. That's distinct from the case we have here, whereas, as Judge Bakke pointed out, that motion for judgment on the pleadings resolved all of the claims against all of the defendants. The case is over. There's nothing to amend. There are no further proceedings to undergo. And so the case should have ended that day, which is what makes the court's order so surprising. The court then, when Ms. Dotson files her motion to amend and the court grants, the court actually faults Dr. Durrani for allegedly waiting too long to raise the affidavit of merit issue. That's a remarkable position to take, given that the court had already granted a motion for judgment on the pleadings based on the missing affidavit. And that statement from the court was simply wrong. Dr. Durrani had raised the affidavit of merit issue in his answer years prior to the court finally granting judgment on the pleadings. As we detail in our brief, it had been a part of the sort of procedural fencing of this case going all the way back to Butler County. And at the end of the day, you have 9 complaints between the two courts tendered by Ms. Dotson, none of which are accompanied by an affidavit of merit. And so for the court, and Dr. Durrani raising it at
You
least
have
3
about
times.
30 seconds if you want to wrap up.
So what you have here, again, is the remarkable procedural outcome of granting a motion for judgment on the pleadings based on a missing affidavit of merit, followed by allowing a plaintiff to amend an already dismissed complaint to attach that affidavit on the theory that the defendant waited too long to raise it. That simply shouldn't have happened. This case should have been dismissed and over, and so we asked the court to reverse the judgment below and remand for entry of judgment in favor of Dr. Durrani.
And I know you wanted to reserve some time, but just so I understand procedurally the proper way this should have been handled, it was dismissed without prejudice to refiling, so they should have filed a new complaint
That's correct,
with
Your
an
Honor.
affidavit of merit.
Which would be material here because in November of 2024, when the amended complaint was tendered, you had revisions to the absent defendant saving statute. So there would have been a statute of repose defense to a newly filed
So
action.
that's the problem. That would, I'll ask them, but that's probably
That's not the sole problem. We think.
why the amended complaint was sought rather than filing a new complaint.
I
new
will
lawsuit.
let opposing counsel explain the reason for their decision. We think it's one problem. It is not the only problem. We think what happened below would have been improper, even if there were no statute of repose issue hanging out. Like, procedurally, what happened here?
No,
should-
yeah, but if there wasn't a statute of repose issue, then the answer would be to go ahead and file a new complaint
Correct, Your Honor.
after the case was dismissed.
Correct.
Yeah, okay.
Thank you, Your Honor. So no further questions. I will see you at rebuttal.
Okay. Good morning.
Morning, Honors. Happy New Year.
Happy New Year.
I like the new display. I just hope that we
It's
got
front
the
and center, isn't
upgrade to remove the ads.
Oh, are there ads coming up?
Upgrade to
Oh,
Pro
gosh.
to remove ads.
That
so
could be
I'm
a tad
waiting for
distracting.
the emu to come up.
All right. Well, my version doesn't have ads, so I wasn't
Okay,
apprised, and
good.
this is the first time that we're using it, so.
Uh,
Thanks for the
well-
feedback. You can start when you're ready.
Thank you. We stand on the judge's decision and how he laid it out. Don't really have anything to add to that. I think he has the inherent power to do what he did.
But, okay, there's lots and lots of case law saying that once a complaint is dismissed in whole, with prejudice, it is treated as if it was never filed.
Well, without prejudice, I think.
I'm sorry, that's what I meant, without prejudice. It is treated, with or without, it is treated as if it were never filed. So, and I've also read case law saying that once a case is dismissed without prejudice, it divests the trial court of jurisdiction to do anything else with that case.
Well,
Do you have any authority or anything to convince me that, no, it wasn't dismissed and that the trial court was not divested of jurisdiction?
right. Well, since you're asking, I think that the court has inherent jurisdiction and ability to do it. And for instance, if you look at Rule 60B-6,
Well, that's different. There wasn't a 60B.
but you told me in your question that it's as if it doesn't exist.
Correct.
So I'm saying, for instance, because you asked me, can I cite to any authority? So I'm analogizing it to 60B-6, which gives the court the ability to vacate a judgment for any reason. And it doesn't accept out, for instance,
And I hear what you're
dismissals.
saying, and what I find interesting is that you never argued that perhaps the trial court turned this into a 60B motion.
Well,
That
he
was
talks-
never argued.
I
Because you're
understand.
right, the trial court retains jurisdiction for
I
60B.
understand what you're saying.
Yeah, yeah, no, I'm just saying it
She
retains
pigeon- Her question
jurisdiction.
pigeonholed me into
Okay.
an ability to bring something up that wasn't in the brief, because she asked me, do I have any
I
authority?
understand, but
So-
I think it would be helpful to you if you hear what I'm saying.
Well, no, I hear what you're saying, but I think that in Judge Reese's mind, he believed, and when you read through his decision, that he had the inherent jurisdiction to do that. If this court disagrees.
Well, the
You know,
trial court relied on 54B, so,
I
and-
understand that's one of the things, that is what he cited. But he also talked about his inherent jurisdiction to do what he was doing. So 54B has nothing to do with his statement about inherent jurisdiction. That's a separate finding of his as to why he did what he
Right.
did, separate and apart from that.
And that brings us back to my observation, which is that you didn't argue that the trial court was using its 60B authority or had converted anything into a 60B or anything of that nature.
I fully agree with you. We didn't
Okay.
argue it. That was a response to a specific question, and that if there's that level of ability under 60B6, I think that supports the judge's decision about what he can or can't do on his own authority. That's how I feel about it. You may feel differently. But I think that the underlying issue was the appellant would like to tell you about how they raised it going back to Butler County. Well, Butler County's not part of this record.
Well, I'm going to stop you for a second. You keep saying 60B6. I don't see 60B, I have the rule pulled up, and I do not see a 60B6.
Maybe I've missed this. It's the
Which-
last reason for authority under 60B.
Okay, so any other reason
which says
justifying
any
relief
other
from
reasons,
judgment.
And it doesn't limit it even to the year, even though this was done within a year. So if I said 6, that's my recollection.
You meant 5, that's fine.
I'm sorry, it's 5.
But it also, 60B also requires that it be on motion.
I understand. You asked me a very specific question, which was, do I have any authority? And so in terms of looking at that, I think that leads to the step that they're not prejudiced because a court has that power under 60B5, and that can be done for any reason at any time. This was even within a year. But what I think the
Doesn't
courts...
60B have to do with like final appealable orders?
Well, that's what they're arguing.
I know that's what they're arguing, but my understanding of a dismissal without prejudice is that it's not a final appealable order.
Well, that's what the judge said, and that's why we are
Right.
standing on...
But also, my understanding is what Judge Bach said, is that once it's dismissed without prejudice, the court is divested of jurisdiction. So why didn't you guys just file a new complaint? Like typically when a case is dismissed without prejudice, that's what is done, right? A new complaint is filed.
Well, this is the route that Judge Reese wanted us to follow.
What do you
So-
mean he wanted you to follow?
Well, there are...
Are there off-the-record
Well, yeah,
discussions I'm not aware of?
That's the problem, is he
Okay.
didn't make it part of the record.
Okay, then we
So I can't
can't
really argue
consider
it, but when
that.
you say, why didn't I do it a certain way? Because that wasn't what the general discussion off the record was as to how he expected it to proceed.
And,
So-
and does this have to do with the fact of the statute of repose problem, that if you would have filed a new
We didn't
complaint?
talk about the statute of repose. He was looking at the issue of that long list of cases and how he wanted to deal with it. We weren't discussing at that point.
So this is a bunch of off-the-record discussions with the judge on how to handle this. But don't you agree that typically when a case is dismissed without prejudice, you would just file a new case?
Well, there's nothing typical about anything that goes on in Dr. Durrani's
I'm learning this.
case, and that's some of which is the problem, because this case had been fully pre-trial litigated.
Yeah.
Meaning records exchanged, exhibits exchanged, everything was, for lack of a better expression, in the can. And so then,
So the affidavit of merit was just forgotten about, or,
this is something that has come up here or there, and when they want to talk about going all the way back to Butler County, this was 3 years since it was last mentioned, and the defense continued to litigate, which is clear from their own brief, if you look at the timeline that they lay out. So
you were thinking the affidavit of merit didn't matter anymore?
well, yes and no. Certainly to the extent that the case, the affidavit of merit is for a few reasons. One is to prevent frivolous litigation.
Yeah.
Well, that clearly wasn't the case because it was moving forward through the normal process. Second, it has to do with notice that there's a legitimate medical claim and the general basis. Well, they already know and knew repeatedly what our same experts were going to say about Dr. Durrani's care and treatment. So yes, from a general answer to your question, that affidavit of merit is a procedural issue. That box wasn't checked. And then the judge was faced with these issues that you're raising and felt the box should be checked. And so through, the defense wasn't sitting there and saying in these off-the-record discussions, oh, Judge, we agree with you. That's a way to solve the problem as you see it. They saw it as a fatal flaw, period, regardless of the fact that they had litigated it for
So the
3
judge
years.
basically looked at it, as they waived the issue by continuing to litigate.
In a general sense, I mean, he certainly didn't say that flat out. It's implied in his decision, and that's why if you follow this sort of serpentine route that he goes through, I think that he reached the correct conclusion. And quite frankly, in reading their brief, there are, you want to talk about some outside of the record statements, and this one I think is important to note.
Well, I think before we go to an outside of the record statement that we cannot consider.
No,
I have
it's
a
there, it's
question.
in their brief, so it's
Okay.
right now, it's in the record through their brief, but not the underlying record. And I think it's important to point out that they talk about Dr. Durrani's extreme suffering from this particular case's litigation for 13 years, and that this is completely unfair to them. These lawyers have never spoken to Dr. Durrani. The trial lawyers have never spoken to Dr. Durrani about this case, and it is on the record in this case that the trial lawyers have never spoken to him.
Well, let's address something that I think can help us in determining this case, all right? I have a very narrow question for you to answer, and I'd appreciate it if you answer this very narrow
I'll
question.
do the best I can.
All right, so the trial court relied on 54B in its determination. And I know there's other language that you're also seeking for us to consider. I'm only going to talk about the 54B language. Was the trial court what is your position? Was the trial court correct or incorrect in its reliance on 54B?
I don't know why they did or did not use that language. I don't know what his thinking was.
Okay,
does
so
not-
you have no position on whether...
I don't see that as the real issue underlying his decision. His
Okay.
decision was based upon what he believed to be his inherent power.
So the 54B language is inconsequential to you?
I think he
and it's about the inherent
pigeonholed
power.
that
Okay.
to then cite some rule, but I don't think that it has direct applicability to what he was doing and what his overall holding is. So I think I find no relevancy to it, because it's not what he based his opinion on.
Can I ask you, I know we already ruled on this, but I'm just curious. You had filed a motion to dismiss the fraud claim in a lot of cases, including this one.
You know what's interesting? While I was sitting here, the Supreme Court ruled on that.
I know, that's why I'm asking. So what, does that have any effect on this particular case under these issues that are raised?
Well, here's the issue. They decided that the dismissal of fraud was allowed, that our motion was granted by the Supreme Court.
But what effect does your motion to dismiss on this case?
Here's why I don't know yet, because that was in that specific case that came out today.
Yeah, but you filed one in this case.
Well, I think that it's dispositive on the fraud issue, but we got to decide if there's even an underlying case to dismiss a fraud from. So until you rule, I don't know what if you rule against me, the impact is of no consequence because there is no case. But if there is a case, the fraud appears to me to be dismissed. And I think that
But
that's
you would dismiss it at the appellate level?
well, that's exactly what the Supreme Court just did.
Well, okay.
I mean, they are an appellate court, and they dismissed the fraud, and you, in one case, overruled our motion, and in another case, asked for supplemental briefing, and then door number 3 opens, and the Supreme Court says, your motion is well taken, dismissed. I think that becomes pretty much authoritative on the motions that are currently pending and what has been previously.
So if you win at this level, if you're going to win this case, if this is just going to go back to the trial court for a trial?
Without fraud.
Okay, okay.
Is that what you're,
Yeah, I mean, I just thought you would dismiss the fraud if it went back,
yeah, if it goes,
not up here.
if it goes back,
Okay.
I would probably dismiss, well, now I will dismiss the fraud because we made the motion, the Supreme Court said our motion's well taken.
Okay.
So I don't think fraud proceeds because we moved to dismiss it. And they've said in that case, it's the same motion in every case. So I don't see them applying different sets of rules.
Okay.
Other than they could say, well, this is a case that hasn't been litigated yet, so you still have the power to do it yourself,
Okay.
which I have done in the cases that are not in the Court of Appeals. Prior to the case going to the jury, I've dismissed fraud. I can't tell you how many times, probably less than 6, but I have had the opportunity to dismiss the fraud claim since we filed those motions, and I've been doing that.
Okay.
Attorney Statman, you have 30 seconds if you'd like to wrap up.
Well, I think, it gets back to what I said from the start. We stand on the decision of the trial court.
All right, thank you.
Your Honors, a few things to cover in rebuttal, and I'm glad I saved the time. The first and most important is that inherent authority does not feature in either of the trial court's orders on the motion to amend. It's not in the motion granting leave to amend, and it's not in the order denying reconsideration. So to the extent Appellee is telling you the trial court was relying on his own inherent authority to grant leave to amend, the trial court didn't tell you that. As to the comment from my colleague that Butler County is not part of the record in this case, in the main, I agree, though I have to point out, if you go back to counsel's motion to amend below, most of that motion is about how there's no prejudice to Dr. Durrani because all of these issues were hashed out in Butler County. And so counsel thought Butler County was relevant to the motion to amend, and that's one of the reasons we point out in the brief. In Butler County, you don't have an affidavit of merit filed with the complaint, despite at least 2 separate court orders telling Ms. Dotson to file a complaint accompanied by an affidavit of merit. Which is why, again, it sort of comes as a surprise to hear, well, this issue was never raised by Dr. Durrani. Of course it was. It was raised multiple times by both Dr. Durrani and by trial courts over the lifetime of this case.
Will that be waived? I mean, I'm not saying that Dr. Durrani waived it, but they seem to be arguing that there was a waiver of the requirement of the affidavit of merit. Can that be waived?
Your Honor, I don't know that it can be waived. But even if it can, you have here a motion for judgment on the pleadings based on the lack of an affidavit of merit that was granted.
Right.
I mean, if there's waiver of a motion that was raised and granted,
Well, I think
There's
the
not much
issue
else
is
to
when it was filed, because remind me, when was the motion for dismissal for the lack of affidavit of merit
So-
filed in comparison to the filing of the complaint, or comparison to something?
so the motion for judgment on the pleadings gets filed in 2023, and we are at that point, a few years into litigation.
Okay, so the issue was the time, then it was the trial court held on to it for quite some time. Is that what happened?
Yes, Your Honor, the trial court did, there was time enough, if I remember right, for us to also brief like a motion to dismiss on the same basis. So there's a motion to dismiss and a motion for judgment on the pleadings that ended up getting resolved in the course of this case. But I have to add, that's not the first time the affidavit of merit comes up in this case. It was first raised
I understand
in
that.
the answer. And, Your Honor, I anticipated there might be a conversation about whether raising it in the answer is sufficient. It is here, because the point of the complaint is to give the defendant notice of the claims raised against him. The point of the answer is to give the plaintiff notice of the defenses that might be raised. And in the civil rules, there are defenses that are waived if they're not raised in the answer. So it cannot be true both that an argument or that a defense raised in the answer is waived because there's not enough notice, and that you could sort of wait as long as plaintiffs did to file the affidavit of merit. I do want to touch briefly on Judge Krause's question with the Supreme Court's decision on the fraud claims. So there are actually two orders related to motions to dismiss the fraud claims. One was granted, that was the motion the motion in Clark. The court denied the motion to dismiss the fraud claims in Courtney and Coblin. There's no reasoning or explanation accompanying either of those decisions, so I don't know if there's anything for this court to make of it. There's actually not even briefing on those motions, partly because, again, from our perspective, the Ohio Supreme Court had not actually taken jurisdiction of the cases, but so the decision to dismiss claims within a case over which the court had not and has not exercised jurisdiction seemed to us like a thorny mess we did not want to get into. We'll let the court take jurisdiction and deal with it there. But you will have that question squarely in front of you in just 8 days when my colleague, Mr. Herzig, has argument on the 20th for the cases that this court ordered supplemental briefing on exactly the question of what do we do with Applebee's.
Did it matter in this case, though? I mean, I know these motions were filed in a lot of different cases, and I'm just asking about, and we have ruled, but I was giving everybody the opportunity to tell us if we were wrong in ruling in this case, and what the effect is in this case.
Your Honor, I don't think it matters in this case because, in my view, the complaint is dead. There are no claims to add or deny. The complaint should have simply been dismissed.
Well, if we agree with you, it doesn't matter, and then if we agree with them, it would go back for trial, right? It would go back for litigation,
Correct.
and then they could dismiss the fraud claim at that point.
I would expect that they would. Yes.
Okay, that's what I'm just wondering, what we're doing with that on.
No, we will not object to the dismissal of claims at the trial level.
Okay, sure. All right.
Your Honor, I think, again, at the end of the day, you have a trial court that issues a decision procedurally that doesn't make a ton of sense. And to anchor it on waiver of all things, having granted the motion for judgment on the pleadings, I think is a difficult order to affirm. And to anchor it on inherent authority, to affirm on the basis of sort of the trial court's inherent authority to amend a complaint after the complaint's been dismissed, would I think be procedurally unique in Ohio, and it's a basis not relied on by the trial court or by extension by Applebee's. There's simply nothing here to justify the court affirming and allowing this case to go forward. And so, again, if there are no further questions, we would urge the court to vacate the trial court's decision granting the motion to amend and remand with instructions to enter judgment in favor of Dr. Durrani. Thank you, Your Honors.
All right. Thank you both for your arguments. We'll take the matter into submission, issue a timely decision, and happy 2026 to all. All right, Geico versus Glendale Body Shop. Good morning.
Good morning.
Would you like to reserve time?
I'll reserve 5 minutes.
Okay. Whenever you're ready.
May it please the court, Justin Becker on behalf of Glendale Body Shop. This case turns on a threshold legal issue where the trial court decided RC 4513.70 applied to Glendale, which is a repair shop. The statute deals with towing services and storage facilities, of which Glendale is neither, and there was testimony to that regard. They're a body shop that repairs vehicles. There is storage incident to the repair process sometimes. The only times they ever charge for storage is when an insurer determines a car to be a total loss. And if it's been sitting on their lot taking up space, they charge for storage because they're not repairing it. RC 4513.70 defines storage facility as any place to which a for-hire motor carrier delivers a towed motor vehicle for storage.
Can I ask you a quick question, though? In this
Yes.
case, the Glendale Body Shop was charging for storage because it refused to return the vehicle because the bill hadn't been paid, right? Like, that's what happened here.
They charged storage from the day they received the car because Geico decided not to have it repaired. So the storage charges continued as long as they maintained possession.
For the day they received the car, they started charging for storage,
Yes.
even though they were trying to determine whether or not it was repairable at that point?
If it had been repaired, there
They
would
would've
have been
waived
no
the storage
charges.
fees.
Correct.
Okay, and then they decided it was a total loss, and then
Geico decides that, not Glendale.
sorry, Geico. And Geico paid part of the bill, but not all of the bill.
Correct.
And so Glendale then held on to the car.
As they had the legal right to do based on a garageman's lien. They had imparted value on the vehicle.
So was there a lien on that?
Just the common law garageman's lien.
Okay, so then so storage was then being racked up throughout this litigation.
That's correct.
Okay.
Because Geico refused to pay the bill.
Well, this-
But if we-
yeah, I think we're all probably getting to the same thing. You go ahead.
Yeah, but if we determine that the statute doesn't apply, what happens then?
Trial court would put on an entry saying it doesn't apply to Glendale as a repair shop. The car's been.
Can Geico even maintain this particular action if the statute doesn't apply?
No, that's their only cause of action was this statute.
It's based on the statute?
Yes.
Okay.
But they can file a new cause of action, perhaps, I don't know. I mean,
Well,
I
it's-
just think the storage thing is quite interesting because,
Geico doesn't have standing to file any action against Glendale.
That's
really,
true.
Because they don't have any relationship. Glendale's contract was with Jennifer Miranda, which is Geico's insured.
which makes I think the storage thing very interesting also, because at that point, that once it was determined that it was a total loss, then you say Glenda Miranda, so Ms.
Jennifer
Miranda,
yeah.
Ms. Miranda would not have ownership of the vehicle anymore,
That's correct.
which was the initial
Geico paid
party.
her-
Let me just, if I can finish, okay? Which was the initial party of the contract when the vehicle was brought into the facility, right?
Correct.
Then the other thing I find interesting is that your storage is being categorized at a moment in which the owner of the vehicle has no ability to take the vehicle off of the premises of your client. So that seems to be contra to the concept of storage, because you wouldn't relinquish the vehicle if you couldn't come to an agreement on what the payment was. You guys were in dispute on the amount of the payment, you weren't relinquishing the vehicle, but then you were charging a storage, and yet the owner of the vehicle, whether it was Ms. Miranda or whether it was Geico, was unable to take the vehicle off of your lot.
Geico or Jennifer Miranda could have taken it any day they wanted to, they just had to pay what was owed. Jennifer Miranda's been compensated. For
Which was in
by
dispute, was it not?
Geico says it was in dispute, contract says it wasn't. Storage charges are in the contract.
Well, ultimately, well, again, I think the concept of storage is very interesting in this case. But let's get back to the statute itself, all right? So you were going through the D1 section of storage facility.
Correct.
Okay? And you were explaining how it's for hire, motor carrier delivers a towed vehicle for storage,
Correct.
okay?
In this case, the vehicle was delivered pursuant to the contract with Jennifer Miranda for repair. And it did advise her in that contract that should the vehicle ultimately not be repaired, there would be a daily storage rate of $125 a day, which was in the contract.
So, looking at the statute, D1, the language is delivers a towed motor vehicle for storage. Does the fact that the body shop charges storage if the car is not repairable, does that make a difference here?
I don't believe that does. It wasn't delivered there for storage.
So what would for storage be?
If it was towed from an accident scene and there was no repair contract in place and it just needed to get off the road, it goes to a storage facility.
Okay. Thank you.
But in this case, there was a contract for repair. Glendale spent resources evaluating the vehicle for that repair. They had to have it towed to BMW dealership for scans and back to their shop. They had to do tear down to investigate what the damage was. And then ultimately, Geico takes over a month to decide they're not going to repair it, and then doesn't want to pay storage charges, which are in the contract with Jennifer Miranda.
So I'm sorry, I know I went over this. So you start, the Glendale starts charging for storage the day that it's brought to the body shop.
If it's not repaired, correct.
Okay. And so basically what it does is if it can repair the car, it'll waive all those storage fees.
Correct.
And if it can't, then storage goes back to the day that it was brought to the body shop.
Correct, with the caveat that Glendale could repair almost anything. It's the insurer decides they don't want to repair it. They determine it a total loss.
Okay.
So, yeah, Geico, or Glendale didn't release the vehicle for a partial payment, and they had no obligation to do so unless their bill was paid in full. And Geico, even if Geico's standing in the shoes of Jennifer Miranda, Geico doesn't acquire rights that Jennifer Miranda didn't have. Jennifer Miranda had no right to possession of the vehicle unless she paid the charges that were in the contract, paid the full invoice.
So I have one question to ask. Because as you're explaining your contract, storage can revert to the moment that the vehicle came onto the property of your client. How is that it wasn't delivered, that the towed vehicle was not delivered for storage? Because that's starting to sound like perhaps the towed vehicle was
It was
delivered
delivered
for storage.
To a repair contract. They initially do tear down, because a lot of times from looking, you can't tell how much damage there really is until you start digging into the vehicle. So they did that work. They had scans done and frame measurements. Ultimately, Geico decides it's not worth it to repair it.
Here, is your client a motor carrier?
No.
And why is that?
They don't even have an employee with the CDL. They have a tow truck, but it's only used for moving vehicles in and out of their facility on their own property.
Okay. If you want to wrap up, you have a few seconds here.
Yeah, and then the second issue was the court capped storage charges. They agreed with the rate was fine. They capped it at 10 days and gave no real reason for that and cited to no evidence of why it should only be for 10 days.
So let me just clarify what this involves. Does this involve the counterclaims?
Yes.
Okay, thank you.
All right. Thank you for
Okay.
your argument. Good morning.
Good morning. I'm going to please the court. Bill Moran on behalf of the appellee. I'd like to address Judge Bach's point earlier, and I think that's a valid one. And I think it also proves that the statute does apply, because your question was, well, what is the remedy that the appellant is requesting? And that is that it would go back to the trial court for further proceedings consistent with the statute not applying. That presents a problem. The person that has the contract with Glendale is not a party to this lawsuit, was never made a party to this lawsuit, and the damages that flow from this are a contractual relationship between Glendale and Ms. Miranda. Geico is the insurance carrier for Ms. Miranda, and this statute allows Geico to present a challenge as to the reasonableness of the charges. So
does Geico stand in the shoes of its insured in this situation?
I wouldn't say they stand in the shoes. I don't think the statute says they bring it on behalf of. So kind of like a party, you know, but Geico's not party to that contract. And oh, by the way, this contract is not before you. It was never before the trial court. It's not, I don't know how you can have interpret a contract when you don't have the other party to the contract as a party to the litigation. So,
So Ms. Miranda was never a party to the suit,
never.
and I think from GBS's perspective, this is a contractual issue, right?
That's what
Yeah,
they
yeah.
appear to be
So
arguing.
what's the statute of limitations on that?
Well, I think a contract is 15 years, but I also think they may be precluded, you know, from bringing a claim against Ms. Miranda because at this point in time, because of they might be stopped from that. I haven't really looked into that issue. She was never made a party. They asked her to be made a party a year into the litigation, and the court denied that. But they also didn't bring that up on appeal. So, you
So
know,
the vehicle's been released?
it has pursuant to the court's order. Yes.
Okay.
And Geico paid, there was an additional, pardon my math, about $2,000 that were owed. The original bill, just so you know, and it's part of the record, it's in Exhibit A in the court proceedings. The original bill was dated February 19th, 2024. The total bill was for $8,400. Geico paid approximately $4,400 of that. Excuse me, $2,400 of that.
Was the rest of it storage fees or?
No, the storage fees that were billed were $4,625. And that storage started January the 11th through February the 19th. I do want to make a point. There is no, this is not before the court as to who determines whether it's a total loss or not. That's not factually correct. The way this works is the vehicle is taken to a repair facility. That repair facility, in this particular case, did an estimate, hey, this is what it costs to repair it, this is the fair market value of the vehicle before. If the fair market value of the vehicle, if the repair costs exceed the fair market value, you don't repair it. So it's not Geico's determination. We didn't prepare a determination as, oh, it's going to be totaled. Once it's totaled, we got this bill. We paid what we felt was reasonable. We mean Geico. And
The
then
bill was about storage.
It included storage.
Okay.
It included storage. In addition to that, it included towing.
Okay, so it's about storage and towing.
Yeah.
Okay, so why don't we
And
go,
there-
why don't we
in
go
fair-
back to the
in fairness,
statute?
there is a breakdown of the whole thing. So
All right.
there are additional charges.
All right, let's go back to the statute itself, all right? Because obviously your position is that it does apply,
Yes.
right? So, under D1, which is the section that deals with storage facility, what is your position as to whether GBS is a storage facility and how the statute applies in
Well,
this case?
I think the fact that they charge for storage, you know, they're in a business for profit. They want to make money.
Okay.
They want, I think if they're billing for storage, you're a storage facility.
Does
So
it
are
ma-
they, I'm sorry, are they a motor carrier? Because motor carrier is a language that applies to both sections,
Yeah,
and that's one of the things that's
I couldn't find a
required.
definition of that, Your Honor. I
Okay.
couldn't find a motor carrier. I don't know what that means.
I mean, there isn't any in that part of the statute. There is elsewhere a definition, and then there's, of
Right.
course, Webster's definition.
And I think it's pretty broad. I mean, I think here's the whole purpose of this. The purpose of this is a classic case for this statute to apply. You've got a dispute. It gives everybody a reasonable method to determine, okay, what's the reasonable cost here? And that's what happened in the court. The court used their discretion, and they said, okay.
No, I understand that. I understand, and you're getting into kind of policy things. I'm just trying to understand motor carrier, because that is a required element.
Yeah, it
Whether
is.
we're going to determine that it's a storage facility, a towing service, or both.
For-hire motor carrier, I mean, I can tell you that that's what they billed for. They billed for storage, they billed for towing. Tow and deliver work, $468, you know, $746 for towing from the customer's house. I mean, I don't, it's in what they charged, I don't see how you could argue that they're not a storage facility or that they're not a towing facility. Either they bill for it or they don't.
Does the purpose for which the car was towed to the facility matter? And the reason I'm asking this is because of the last two words of D1, which is for storage.
I think they're arguing that it does.
Okay,
I
what's
don't-
your, what?
I
it-
don't think it
Why
does.
not?
Because they billed for it. I mean, they sent a bill for it. So if you, don't charge us storage if you're not a storage facility, you know? I mean, I think it's just that simple.
I mean, it sounds like what you're saying is they could be doing more than one thing with the same vehicle.
Oh, they
They
did.
can have more than one role.
They did, yeah, and they did here. And the goal was, you know, to determine, and they make that determination because they prepare the estimate. They send that to Geico and they say, this is the cost to repair it. And then Geico says, oh, well, the cost exceeds the fair market value. That's why we're not going to get it repaired.
So you're arguing, I understand your storage argument, but you're also arguing that they were a towing service, even though they contracted with a towing service?
Well, I mean, for purposes of this case, they billed for towing.
Yeah, but
I'm.
because they actually
I don't know if-
stored the vehicle at their facility, but they
Right.
they didn't tow the vehicle. They contracted with another service and then passed that
Right.
through.
I mean, they billed for towing. I'm not going to stand here and say they're a towing facility for purposes of the statute or not, because I don't think it matters. I mean, Geico didn't get another bill for towing.
So it doesn't matter because you're focusing on the storage piece.
I don't want to concede that argument,
Okay.
you know, because they, and here's why, Your Honor.
Well, I'm trying to
They billed
understand
for
the
it.
difference. I understand you're saying they billed for it.
Mm-hmm.
But like if they say they didn't store the vehicle at their facility, it was stored elsewhere. I mean,
And
are
they
you
wouldn't- They wouldn't bill for it then.
well, no, but they
happens all
pass
the
through the
time.
bill. So if
Yeah,
they're
but
just
that happens all the time.
okay.
Yeah, they get a.
So just by virtue of billing for it, you're saying they fall under the statute.
I believe so.
Is it that they billed for it? Is it that they made that part of their services saying, and we can have it towed, we can have
Well,
the
that's what
vehicle
they
towed?
did, yeah. And they argued that was part of what they did. I mean, and that's why they billed. I mean, I don't,
Yeah.
and he
I
even
mean,
said in his
I'm,
argument.
frankly, I'm still stuck on motor carrier, I'll be honest with you.
Yeah.
Because
Well-
motor carrier can be dispositive of this because it presents itself in both the D1 and the D2 section. And so while I understand that it's not defined within this particular statutory
Well,
section.
But I think you have to use the words before motor carrier, for hire. I mean, I think that's.
Oh, there's,
yeah, that's-
there's multiple elements
yeah,
here.
yeah,
I get, and
so-
I think for hire,
Yeah,
just
yeah.
the word for hire, I don't
Right.
think that's in dispute by either side.
I agree.
Okay, so,
Yeah.
so.
Well, and that's what.
So what is your,
And
what
that's
is
why
your
I wanted-
position on what the term motor carrier means?
Motor carrier? It's any facility that, that is for hire.
Okay.
And tows and charges for towing and stores and charges for storage. I mean, and that's what they did here. They charged for both of those.
So it's defined by the latter part of the statute. If you're towing, or if you're hire and you're towing and you're for
But-
hire and you're storing, then
But-
then you're a motor carrier.
Right, but I also think, Your Honor's question is point on, and it backs into the whole purpose of the statute to allow the insurance carrier to do this. And that is, well, what's the remedy here? Because if we go back to the trial court, I mean, does that mean that Geico gets refunded all the money that it's paid? And then there's an action against Jennifer Miranda because she's the one that entered the contract. And then that you have the whole issue whether they're stopped from presenting that. So I don't think there's the remedy that they are asking for as a possibility.
Well, that's only if this is not intended to apply to a repair shop.
Right, and if it applies to a repair shop, then the statute applies, and, you know, that. then the-
Right?
then the-
I mean, if
then
it
the
applies to a
court-
repair shop, then that, it applies to a repair shop. But here, with regard to the issues apply to
Well, I
motor
think
carriers
I
that
think you
are
just said it
towing.
yourself. I think a motor carrier does include a repair shop. I mean, that's, I don't think there's anything in the statute that says it doesn't.
Well, a storage facility is any place to which a for-hire motor carrier delivers a towed vehicle for storage. So the storage facility doesn't have anything to do with being a motor carrier.
Oh, that's, yeah.
It's only the towing service it means that it's a for-hire motor carrier. The storage facility doesn't have to do with the motor carrier. Does it?
Maybe that was your point earlier, yeah.
Yeah, that's why I'm just saying that you have a storage
Yeah, so I mean,
facility
I'm not
and you
gonna,
have a
I'm
tow.
not gonna concede the towing, but our argument is stronger on storage.
Okay.
That's fair, yeah.
Okay.
Absolutely, no question. But I still think the statute applies to this case, and I think this is the prime example of why it does, because you've got to, and here's the other thing, you know, this was taken 2 years ago. January 11th, 2024 is when this vehicle was taken there, you know, and for Jennifer Miranda, you know, that's 2 years ago. She signed this contract, and now we're still talking about it, you know, so, now she's been made whole by Geico because Geico paid pursuant to the contract, insurance contract, not the,
Right, but I mean, she doesn't have title over the vehicle for a portion of these storage charges.
technically, technically, the title only transferred after Geico took possession after the court's order, because we didn't,
Okay.
we never, and that's a good point, Your Honor, because we couldn't apply for title because we didn't have possession of the vehicle. And we're not allowed to do that until we get possession of the vehicle, then we go apply for it.
Which goes back to why I think the use of storage is quite interesting here for that period of time where there was a dispute on the bill.
Yeah.
And so storage seems to me like, you know, the person has the ability to retrieve and doesn't retrieve, as opposed to the person who's charging the storage has complete authority as to whether that vehicle can be released or not.
Well, I think.
That's for another day.
Yeah, I do too, but I do think that, and that, I think that points out, and that's where the court, when they presented damages for $52,000 worth of storage, I mean, that was,
Yeah. I have sort of a totally inconsequential question that is all about curiosity, which I rarely ask questions on curiosity. You're in this industry.
Please indulge me.
Yes, you're in this industry. This language about storage and all of this stuff, is this industry standard?
Is this, yeah, what happened here is pretty, in the sense of, yes, there's and what do you mean by that? Like
In other words,
industry standard?
this accrual of storage during this term, that there's the dispute and
Yeah, I would.
use of the-
Yeah, if we got billed for it, yeah, and we broke down what we felt was reasonable.
So you
know,
paid some of the storage?
Yeah, we paid,
Yeah.
we absolutely paid storage. When we paid the disputed amount, within 30 days of getting the, and we got the bill on February 19th, we filed suit on March 4th. So we paid the undisputed amount. It included storage, it included towing, it including some for breakdown. The challenge was, we thought it was only worth $2,400, and they billed us for $86. But we most assuredly, and that's part of the record, we definitely paid for storage, we definitely paid
All
for
right.
towing.
All right, thank you so much for your argument.
Thank you, Your Honors.
Glendale's position is that Geico has no basis to challenge the reasonableness of their charges because it's a contract between Jennifer Miranda and Glendale. Geico's not involved with it. If this statute were to be found, well, first of all, if the legislature wanted it to apply to repair shops, they could have put that written in there quite easily. If it's determined that it does apply, it supersedes every repair contract and allows an insurance company who's not a party to the contract to just decide what they think they should have to pay, which they're not.
Is this normal for, is it typical for repair shops to to charge for storage?
Yes,
Okay.
yes, insurance companies pay it all the time, including Geico.
Okay.
Yeah, the statute doesn't supersede the contract. The parties were free to contract to whatever they wanted to. They did. Geico has no standing to dispute those charges and had no right to possession of the vehicle until they paid the bill on behalf of their insured.
What is your position on the definition of motor carrier?
I would think it involves being hired to drive people or something else from one location to the other, which Glendale does not do. They contract out towing they hire someone to tow it from their shop to, in this case, BMW, and then back to the shop. Or initially it was from Lexington to up here. I believe I'm done if there's no further questions.
All right, thank you for your arguments this morning.
Thank you.
We'll take the matter under submission and issue timely decision, and happy 2026. All right. Good morning.
Morning, Your Honor.
Would you like to reserve time?
Judge, I reserve 2 minutes, please. for-
All right. 2 minutes, all right. You can start whenever you're
May it
ready.
please the court. In the trial below here, the state had 3 witnesses who were at this party. Not one of them testified that they saw a gun in the hand. One of them Mr. Henderson testified he ran away with a gun after the fact. Nobody said before the shooting that there was a gun in his hand.
Could the jury, though, could the jury have inferred that he had a gun before the shooting based on, the testimony that he very quickly, got the gun and shot the intruder? Could the jury have inferred that?
I don't think there was any, I'll take it back, there wasn't any evidence for them to make that inference, because there was just no testimony about that.
So really, you're saying that your strongest argument is sufficiency?
Well, I've got two, and
I know you have two. I know you have two.
I don't want to ignore that.
I'm
because-
not asking you to ignore it, but it sounded like in your response, it felt like you were kind of zoning in on the sufficiency.
Yes.
Okay.
Well, let me push back a little bit on that. I mean, the statutory elements were that the person, he conceded that he had the disability, that he was under a disability, correct?
Yes.
So the only other thing that the state had to prove was that he had a weapon. The rest of it is a defense.
He had constructive possession of a firearm
Okay,
when he shot Mikhail Booker.
yes, so that has been, I mean, he admitted to holding the weapon and shooting the intruder, correct?
He did.
I mean, that was part of his self-defense claim. So, in self-defense claims generally, sufficiency is not anything that, you can't argue sufficiency because the person has already admitted to all of the elements. The issue at trial is whether their defense absolves them. Correct?
That's a general rule for self-defense.
Okay, but to me, and please feel free to correct me otherwise, maybe I'm just misunderstanding, but to me, the same concept applies here. That he had already conceded that he was under a disability, and he admitted that he possessed a firearm when he shot the intruder. So doesn't that meet all of the elements of the crime, of the offense?
Well, there's an exception, self-defense exception under the State versus Hardy.
I understand that, but under the statute itself, those were the elements, and the elements were met. And then he can forward the self-defense, which the state has to disprove, but he can forward self-defense. But the elements have already been met, correct?
Yes, I think I agree with what you're saying. He had a gun and he fired it. He admitted having the gun.
Okay.
If he used that gun in self-defense, which is what he testified, the state has to prove that he had the gun before he used it in self-defense, not after.
Right.
Not running away
Right.
with it, but before he used it.
So the state has to disprove the self-defense that was forwarded by the defendant.
I think what you're saying, if I understood your answer, is that the burden for the state is to establish that the use of the gun went beyond the self-defense.
Before
It
the
was before the-
self-defense occurred,
exactly.
the state had the burden of proving he had constructive possession of that firearm.
Exactly.
And that goes to, that's a sufficiency question.
In other words, in other
I
words,
see.
if
Okay.
the defendant used a firearm and used it for self-defense, but it wasn't their firearm, they only used it for self-defense, it came out of wherever, there wouldn't be a weapons under disability charge.
He would fit under that, the
Right.
conduct would fit under that exception
Right.
in Hardy.
Okay, so the issue here is solely whether outside of that moment that he had, whether he had a gun outside of that. In other words, did he bring it with him, that sort of thing.
Yeah, my self-defense argument here is, insufficient evidence argument here is he didn't, there's no proof in this record that he had the firearm before using it.
Because there's no dispute, the state's not even disputing the self-defense. We're just going to accept, because, he was acquitted of murder and felonious assault, presumably because of the self-defense argument. And I didn't even see the state's not seeming to argue anything against self-defense. They're saying, we have proven that that he had the gun prior to the shooting, that he constructively possessed the gun.
Yes.
Or possessed the gun
That
prior to,
appears to be their argument based
Right.
on their brief. And
based on circumstantial evidence.
yes, I suppose, they want you to, they want to say that you can make inferences here, that the jury could have made inferences that he had.
That's
the
all
gun.
they have, right? Like, they put together all of the evidence that they had, that there's nobody that testified that said, I saw him with the gun prior. So the state's putting together their circumstantial evidence case to demonstrate that the only logical conclusion, when you look at the evidence in the light most favorable to the state, is that he in fact had the gun prior to.
I would agree that's what they're trying to do, and that's why in my reply brief, I went through those 7 points that they raised, and I counter-replied, sort of. This is not evidence, this is not proof beyond a reasonable doubt. All of them, when summed up, aren't proof
Well,
beyond a reasonable doubt.
that's not, we're looking at whether the state had sufficient evidence when we look at the evidence in the light most favorable to them, right? On sufficiency.
There's sufficient evidence has to amount to proof beyond a reasonable doubt that he had the firearm before using it in self-defense or defense of others.
Okay. And so can you go through a little bit for us now why what they put together doesn't amount to circumstantial evidence that he possessed the firearm prior?
Well, I did that in my reply brief, so I'm not going to, I'll tell you that. He ran past, the one steps are, and I did this in a counterpoint fashion, it's kind of an unusual belief, but each one of these points I've counterpointed. He had the gun afterwards doesn't prove that he had the, because Henderson testified he had the gun after, doesn't prove he had the gun before.
Okay.
No one else has been observed at the party, a gun with the party. Well, that fits with Mr. Courtney's story here. It was concealed under the coat. Rico Keeling kept it concealed under the coat.
As you're going through this, I want to go back to the point you were making, because one of the arguments from the state is that Courtney was observed with the gun still in his hand when he fled, okay? So does that go in any way, shape, or form into whether he had it before?
Kyle Henderson said he ran past me with a gun while he was going down the steps. No, it matches perfectly with his story that he picked up the gun and then and used it in self-defense and then ran away with it. Because he had it running away doesn't mean that he had it before.
So he's allowed to run away with the gun? He's just
Yeah,
not
but-
allowed to have it before the use of self-defense?
Apologize for using the word yeah. Yes, he's allowed to run away with it.
Okay.
The jury was instructed, the exception applies, and then the trial court properly instructed the jury, they had to prove that he had a constructive possession of the firearm before using it
Okay,
in self-defense.
because another argument made by the state is no one else had been observed with a gun at the party.
Well, that's because it's under the bed. Rico Keeling left it under the bed under his coat. That would be one answer.
Okay.
That it matches his story.
Okay,
So he did testify that he left the gun on the bed, and there was no gun found in the apartment. So could the jury then have disregarded his testimony as being not credible?
The jury has the power to disregard his testimony.
Okay. So
But-
if you put his testimony aside, then no one else saw a gun at the party. The gun came from somewhere, and then he shoots the gun and runs out with the gun. I mean, that's what we're left with, right?
That's not enough to prove he had the gun before using it in self-defense.
That's what I'm struggling with.
It's not, it's just not enough. And in closing, the prosecutor said, I submit that you had the gun. And then she argued what you just said. He might have ran away from it. He must have had it. Well, I'm suggesting that's not sufficient evidence that he had the gun.
That
prior to
alone isn't sufficient evidence. I'm looking at the other things that the state altogether pointed to for
Well,
there to be an inference that he's the one that had the gun on him.
But you can't, the jury can't, and this court shouldn't, just infer that he had the gun. Those inferences don't sum up to proof beyond a reasonable doubt that he had the gun before using it in self-defense or defense of others. So everyone ran away from the Airbnb, so Mr. Courtney ran away from it.
I mean, it seems to me that, I think what you're really saying is that they're sort of improper inferences because they would apply generally in these like he still has it with him and as he leaves, right? Well,
Right.
he just finished using it, so most people would also have it with them as they leave, I think is what you're trying to say.
The inferences don't.
I'm not saying I agree or anything, I'm just trying to understand your position.
Inferences don't sum up to proof beyond a reasonable doubt that he had the gun beforehand. And I've done this in my reply here. The video doesn't show a firearm. You can see the video of him leaving, his hands in his pocket, he doesn't show him leaving with a firearm. He could have had a firearm, I suppose, in his pocket, but the video doesn't show a firearm, I believe. So, yeah, he admitted he had used a gun in the past few years. He was a good shot. That doesn't bear on that he possessed a firearm before using it. And in fact, Rico stood near the door. That really proves nothing. So there's insufficient evidence here in this record, and the jury must have speculated that he had the firearm beforehand. And that's why you should reverse this on insufficient evidence. Turning to my second point, the manifest weight evidence. There is a presumption here because Booker broke into this apartment. There's a presumption of self-defense. Presumption that Mr. Courtney used this gun in self-defense, and that was never rebutted. So when you're weighing the evidence here as a 13th juror, that presumption that he shot in self-defense is not rebutted. To that extent, the jury's verdict of guilty is against the manifest weight of the evidence.
Well, I mean, the jury found that, acquitted him on the murder charge, and I think, I don't remember, was it a felonious assault charge as well?
It was a weapons under yes, they acquitted
Yeah, they
him.
acquitted him on those two charges,
Yes.
but found him guilty on this charge. Wouldn't that suggest that the jury found that, yes, he did obviously shoot the intruder based on self-defense, but that he had the weapon before he shot the defendant, or the intruder?
Well, they must have thought that because they returned a guilty verdict.
Right, on the
That
one
guilt-
charge.
Well, that guilty verdict is against, it's not supported by sufficient evidence, because they have to speculate, because there was not enough testimony that Privy had before. And it's also against the manifest weight of the evidence, because there's a presumption he used it in self-defense, because Booker broke into that apartment. Mr. Courtney gets that presumption, self-defense or defense of others. So it's still there. The state had to burst the bubble of that presumption, and they didn't do that. No evidence said that Mr. Courtney shot him for any reason other than self-defense. So there's still standing a presumption that what was done in self-defense.
Well, I understand that the jury found that he shot in self-defense. That's what the jury already determined, and that's off the table. I mean, the only thing we're looking at here is whether it was against the manifest weight for the jury to determine that he had the gun without a reason for self-defense before the intruder came in.
Okay. That also is against the manifest weight of the evidence. But what I'm suggesting is if you discredit if you're weighing the evidence and you choose not to believe Mr. Courtney's story, there's still a presumption of self-defense that what he did was in self-defense here.
Right, the state had to disprove
Right.
self-defense.
Right. I mean, if it's against insufficient evidence, it's also against the manifest weight of the evidence on the point of whether there was any evidence showing he had the gun before. So I would ask
thank
you to rule on both in Mr. Courtney's favor and reverse this verdict and this conviction and discharge it from further prosecution. Thank you.
Thank you.
Thank you.
Good morning. Happy New Year.
Your Honors, the state stands by its brief here. I think that the circumstantial evidence can certainly be added up, and the jury certainly could infer that he brought the gun with him. I think that's clearly probably what they did in light of how this went down, how quickly the shots were fired, et cetera, the stuff that you alluded to. But I think, I'm starting to wonder if the state, in emphasizing circumstantial evidence, might have made this more difficult than it needed to. And the reason I say that is, I think what this boils down to is the Hardy exception available to Mr. Courtney, and I don't think it is here. If you look at case law that interprets Hardy, courts say that if the defendant obtains the gun or retrieves the gun in anticipation of a confrontation, the Hardy defense is not available to him. And if you just read what the defendant says in his own words, he proves the weapon under disabilities case for the state. When the knocking first happened at the apartment, and if you read the accounts of the witnesses there, they didn't know exactly, some suspected it was the victim, Booker. They didn't know. They went to the door and they were going to open the door. They wanted to see who it is. While they were doing that, the defendant admits he was going back to get the gun. So what is he doing? He's retrieving a gun, knowingly obtaining a gun in anticipation of a confrontation that hasn't happened yet. And isn't that exactly what weapons under disability says? You can't get the gun, you can't have a gun. And the Hardy exception says, well, you can in self-defense, but I think that contemplates a situation where...
Well, I mean, in order to use a gun in self-defense, you have to get a gun. So
He
either
knowingly, yes.
either you had the gun, because the language from Hardy is knowingly have the gun previously. So it seems to me, right.
Yes. What is previously?
Exactly. Previously, is it the millisecond before he uses it? So him retrieving the gun in anticipation that it might be needed for defense of himself or others, right?
Correct.
I think there's an
That renders the
argument that
Hardy
that's
exception
tied
unavailable.
to the self-defense itself, right? So what
I'm sorry. Excuse
you're
me.
saying that there's knocking on the door, but doesn't Booker just kind of,
He bursts in.
yeah, he
they
bursts
actually
in. I don't think he
open the door.
knock, 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 who's there? I think it's-
He burst in
Yeah.
below, and then I think they opened the door for him. into the
Okay.
apartment. But
And
yeah,
it-
he burst in, yeah.
Okay, so it's after the bursting in that Courtney goes to retrieve the gun.
Not if you read all these
Okay.
accounts, no. They hear knocking, and, Rico and Henderson go to the door to say,
Okay.
who is it, who is it? And he admits, I go back, I gravitate, he says it himself, I gravitate towards the bed because I'm looking for the gun. That's what he says himself. So while they're going to see who might be at the door, he's anticipating confrontation. He gravitates towards the bed where he claims he saw the gun, and he retrieves it. And, based on the case law, that's exactly the kind of behavior that renders him ineligible to claim the Hardy exception. He retrieved the gun in anticipation of a threat.
It's all in the same, they knew that there was potential danger at this door, right?
Sure,
Okay.
yes. Yeah.
So that seems a little bit different than some of the cases that you're relying on, where, I think there was a case where a guy drives up and he had the gun in the car door, and he gets out, and then there's a confrontation, and he runs back to the car and gets the gun. This, to me, just seems like he had seen this gun over on the bed, there's danger at the door, he runs and grabs the gun. I'm more interested in your argument on the circumstantial evidence and how we can have, because it seems like you're not arguing about self-defense here. I think the jury bought that he shot in self-defense. He was acquitted of the serious
Not
crimes.
contesting that.
You're not arguing that he shot in self-defense. What you're saying is that he had that gun on him prior. Therefore, that's weapons under disability, right?
Correct.
And that's the sufficiency piece that you all had to prove.
Yes.
And so that's what I'm interested in, because there is no direct testimony that he had that gun on him.
Right.
And so what is your best circumstantial evidence to paint a picture of the circumstantial evidence of why he had that gun on him prior to this self-defense incident?
Well, the totality of the circumstances, to coin a phrase, it's the way everything stacks up. He's shot immediately upon, Mr. Booker entering the room. it doesn't make it credible that he had time to go retrieve the gun after the threat was in the room and then aim perfectly. The timing, his lack of credibility, the fact that he's seen with the gun afterwards as though he brought it, he's going to take it with him. The circumstances in which he left, he was the first one out the door. I mean, as soon as this happened, boom. He was
They were all running out the door.
He was the first one, though. He was
Wow.
out first. He almost knocked over Henderson's girlfriend, I think, on the stairs in such a rush to get out. All of this, I think, together.
Can I ask about a couple of the ones that
Sure.
you had said his admission that he had fired a gun within the past 3 years indicated a knowing willingness to possess a gun despite his disability.
Right.
Okay.
It's all part of the circumstances of a guy that likes guns, knows guns, shoots them for fun, target practices. And if you'll notice, he was incredibly accurate. I mean, Henderson was laying right over Booker, and yet he's able to shoot Booker and not Henderson. He's a good shot, and he was able to shoot within seconds of this Booker's entrance in. Just the timing itself is stunning, how fast this happened.
Well, wasn't it, I mean, I watched the video, and it looked like, first of all, it's a very small residence, but it looked like the bunk beds were like immediately behind where the seating was, correct? Like maybe just a step, and then the front door was right on the other side of that seating area.
Right.
So it wasn't far. I mean, it was within, maybe the whole thing was 10 feet at most.
True, absolutely true.
So him shooting, pretty much immediately, I mean, it was really close. So if he had a quick reaction time, that doesn't necessarily mean that he had already retrieved it before the intruder came in.
Well, it doesn't necessarily mean it, but it's certainly enough for a jury to infer it properly from what it had before it.
So that's just one of the factors that shows it.
Absolutely. You're right. You don't have one witness that said, I saw him enter the place with a gun. That is true. We don't have that.
Well, they're all saying that, all of the witnesses are saying they didn't see a gun at all at the party, right?
Right.
Like they didn't see a gun on the bed. Rico didn't testify, and
Well,
allegedly it was his
yes.
gun. Well, according to Courtney, it was his gun.
He didn't, although,
Right.
again, that kind of undermines defendant's credibility. I mean, if it was on the bunk bed, and it is a close quarters, if it was laying there,
Right.
wouldn't somebody have noticed it, seen a bump on the bed? He claims he threw it back and the officers never recovered it. Nobody else saw it later after this happened. So you just add all this up, just the whole way it went down. The jury had more than sufficient evidence. And it is circumstantial, but circumstantial evidence is fine. And I don't want to abandon that Hardy. I still don't think even under Hardy that it's eligible, that exception is eligible. He's eligible for that because he consciously, deliberately made a decision while they're going to the door, before this even happens, before there's actually him coming in and saying, I'm going to kill somebody, he's going, we're here to get the gun. And Hardy's not available to him under the circumstances. He's knowingly obtaining the gun.
So you're saying that simply because he went to get the gun before,
In anticipation of a
in
confrontation
anticipation,
that hasn't happened yet.
that then exempts him
It may
out
happen.
of Harding?
Well, it did, but it hadn't happened yet.
Okay.
But that shows you where his mind is to get that gun.
And you agree that we are to look at this under a sufficiency analysis?
You mean the
Whether
light
this, I
most
mean, this is
favorable to the
this
state?
is a state burden that they had to prove not only constructive possession, but the constructive possession prior to the self-defense.
Yes.
So it would be a sufficiency.
Yeah,
Analysis.
Well, yes, yes.
Okay.
And I think the defendant proves it for us by his own testimony, but I'm just repeating myself. Unless you have any questions.
I do have a question. As I understood Courtney's, I believe it's Courtney's testimony, there was a coat on top of the gun. The gun was on the bunk bed. There was a
Yes.
coat on top of the gun. Okay.
Yes.
Was there any testimony or any evidence that's inconsistent with there being a coat on top of the gun?
I think just his. I think he said he went there to get cigarettes out of Rico's coat with Rico. And Rico had to move the coat to pick it up to get the cigarettes out, and that's when Courtney said he saw the gun laying on the bed, which would have made it underneath the coat.
Right.
But that only came from the defendant.
Okay, so, because my question is, was there any testimony that's inconsistent with, or any evidence that's inconsistent with Courtney's testimony about the coat being on the gun?
Not specifically.
Okay.
It just wasn't corroborated by anybody. Nobody testified that, yeah, there was this gun underneath this
Okay.
coat. I mean.
I understand,
that was
yeah,
lacking, but-
yeah. Because I think one of your arguments, like, nobody saw the gun, but the testimony, the only testimony, whether there's any weight given to it or not, is that there was a coat on top of the gun.
That's the only testimony
Right.
about it, yes.
Okay. All right, I'm just trying to piece this all together in my head.
I understand.
All right, thank you.
Your Honors, the Hardy exception necessarily includes time to get a gun once you perceive there's a threat. So this whole case falls under the Hardy exception. He has to have time to get a gun to use it in self-defense of others. On a totality
And I
of
think
this-
what he's arguing is that he gets the gun at a moment that there's no, that the gun isn't necessitated yet, in anticipation of the possibility. It feels almost like an argument that Hardy doesn't apply in an attempted self-defense. In other words, like, that would be like, oh, I went to get the gun, but then, oh, we didn't need it, so I put the gun back. And that moment, brief moment of having the gun in the possibility, right? But then in actuality, not needing the gun, that's enough for the weapons under disability, and that Hardy would not apply in that moment.
I think everything happened really fast here. And
I mean, that's not what happened here, but in order for that argument to stand, that it seems to me what flows out of that is if somebody, the affray hasn't really escalated, but thinks that there's a possibility, retrieves a gun that isn't theirs, no affray escalates, doesn't use the gun, puts the gun back, that they can be charged with weapons under disability for that period of time.
But that's not what happened here, as you pointed out.
No, I understand that's not what happened here, but,
But the exception is broad enough to include time to get the gun. And on the totality of the circumstances here, it doesn't amount up to proof beyond a reasonable doubt that he had the gun before using it in self-defense.
all right.
Thank you.
All right, thank you. Thank you both for your arguments this morning. We'll take the matter into submission, issue a timely decision. And happy 2026. We got one done, many more to come. Karen, thank you.